Welcome back to UK Knowledge Guru. In this video, I will guide you what is Immigration Judicial Review, and I will also guide you how to fill the form of this review. Immigration Judicial Review is a type of court proceeding in which a judge reviews the lawfulness of a decision or action of the Home Office. In an immigration judicial review, the judge will look at the way in which the Home Office reached its immigration decision, rather than whether the immigration decision was right or wrong. In other words, immigration judicial review involves a challenge to the process followed by the Home Office when reaching an immigration decision, rather than the conclusion actually reached. Immigration judicial review is a remedy of the last resort. You will need to have exhausted all other available complaints or appeals mechanism before pursuing judicial review. So for example, you have applied for the skilled worker visa and it got refused, and it was refused on the basis of the interview. In the refusal letter, it says that you didn't meet the proper requirement, etc. Now it says at the bottom of the last page that you can apply for the administrative review. So you need to apply for administrative review until you don't get the decision on administrative review. You can't apply for judicial review. So once you get the decision and it's against you, then you will go for this option. You will not be notified by the Home Office of your right to challenge a decision by way of judicial review. Judicial review applications can be costly, risky and complex. I'll show you in this video the fees of this as well. So let's understand when you can apply for immigration judicial review. So you can apply on the basis of three main grounds. Number one is illegality. Number two is procedural unfairness. Number three is irrationality. Illegality means the decision maker did not have the legal power to make the decision. Procedural unfairness. The process leading to the decision was improper. Number three is irrationality. The decision under challenge is so unreasonable that no reasonable person acting reasonably could have made it. If a decision by the Home Office is found to be unlawful, unfair, irrational, or contrary to human rights, then the decision will not be remade by the judge. Instead, it will go back to the Home Office for consideration. So when you apply for judicial review, the judge can say that this decision is not right. Can the Home Office reconsider this? The judge don't give decisions that you are allowed to come to the UK. As mentioned above, the judicial review is not an appropriate legal procedure if you wish to argue that a decision of the Home Office is simply wrong, or if there is another avenue of appeal or review available. Now let's understand the time limit. So for judicial review application, challenging a decision of the Home Office must be made promptly and must be sent or delivered to the upper tribunal so that it is received no later than 3 months after the date of the decision that is being challenged. This time limit means that a work or business visa judicial review application should be made as soon as possible. Now let's quickly understand the judicial review process. So the process is, first you will go for pre-action protocol. Before commencing immigration judicial review proceeding, you should send a pre-action protocol letter to the Home Office. The pre-action protocol letter is legal submission which explains why the decision of the Home Office is unfair, irrational, unlawful, or breaches human rights. The pre-action protocol letter will also warn the Home Office that judicial review proceeding will be commenced if the decision is not withdrawn. Upon receipt of the pre-action protocol letter, the Home Office will review the decision in your case, normally within 14 days. Now, what if the pre-action protocol is not being considered? So, if there is no satisfaction response to your pre-action protocol letter, the next stage is to apply to the upper tribunal unless your case falls within the jurisdiction of the administrative court for permission to apply for judicial review of the decision you are challenging. Immigration judicial review proceeding must be issued promptly and within 3 months of the original refusal decision. Now, what happens after that? If the Home Office decide to defend its decision, judge of the upper tribunal will review your immigration judicial review claim and the Home Office defense statement and make a decision on whether to grant permission for judicial review or not. Most permission decisions are made within around 3 to 4 months. If permission is granted by the upper tribunal, then Home Office may decide to withdraw its decision and make a new decision typically within 3 months. If permission is refused by the upper tribunal on the papers, then unless your claim has been certified as totally without merit, you will have 7 days to request to renew your application for judicial review orally before a judge of the upper tribunal. Now let's discuss the fees of judicial review. The fees for the initial judicial review application is £154. It will go up soon, so it will go to £169. The fees for requesting that a refusal of permission is reconsidered at an oral hearing is £385. The fee for the full judicial review hearing is £770. Reduced to £385 if you have already paid £385 to have permission reconsidered at an oral hearing. If you are on a low income, you may be eligible to apply for reduction in these fees. Now let me show you the application for judicial review form. So if you wanted to submit this judicial review, you need to complete this form. So what this form is, so you need to pay fees for £169. This form must be used for making an application for judicial review. You must complete every section. You must ensure that section 12 is completed. So over here you have this, when should I fill my application for judicial review? Before you begin your application. So they have explained, which we just discussed. So in which upper tribunal region you are making your application. So you select that, details of the applicant, you provide all that details, legal representative. So if you have legal representative, solicitor, barrister, whoever, you provide all that detail. And then in the section 3, detail of the respondent. Who is the respondent? The Secretary of State, the first tier tribunal immigration, another person, so whatever the details are. Details of other interested parties. Fill that up. Details of the decision to be judicially reviewed. Jurisdiction of the upper tribunal and procedure. Then section 7, detail of the application for judicial review. Section 8, other applications. Section 9, supporting documents. So in supporting documents, statement of fact and ground, a copy of the decision under challenge, application to extend time, application for any other directions, evidence for the application for judicial review, evidence for any other applications made, a copy of the civil legal aid certificate. And then after that, section 10, additional information, section 11, statement of truth, section 12, tribunal fees. So £169, as I said, this is what you need to pay fees in the upper tribunal. So they have mentioned all the details over here. I'll put this form in the description as well, so you can go through. They have also provided where to email. So you have these email addresses. This is the address if you wanted to use the post. If you are legal representative, you must send this form for any other supporting document using HM court and tribunal e-filling service. So they have provided all the details over here. If you wanted to use e-filling service, then this is the link to register and access. I'll put this link in the description as well, so you can use it. Further, it has more details over here at the bottom. Over here, form and fees for the user. So £169 if you filling up UTIAC1. If you filling up underwritten rule, so understatement, that's no fees, no fees, no fees. And then if you doing number 5, UTIAC15, urgent consideration without form, then £281. So they have mentioned everything on this form. There is you can go through with. They have also mentioned that how the system works. So application issued by upper tribunal, fees is £169. Then within 9 days of making an application, the application provides sealed copy of the application. They have mentioned that within 21 days, case sent to a judge for a permission decision on the paper. Then judge grants permission to proceed. Judge refuses permission or does not admit the application. If judge do this, then what will happen? If judge grant you the permission, then what will happen? Within 9 days of being sent to the judge decision application, pay fees to continue. £847. If that's done, then it comes to this substantive judicial review hearing. Now let me show you gov.uk. If you go on gov.uk, apply for judicial review in an immigration or asylum case, you will fall to this page which you have all the details which we just discussed. It tells you how to apply, how to serve copies, what happens next before the final hearing, what happens at the final hearing. And over here, it will provide you all the forms which we just discussed. On the right side, it also provides you related content. So for example, resolve a dispute with Home Office through the pre-action protocol. Immigration and Asylum Chamber forms appeal a visa immigration decision if you are in the UK. So they have provided all the details over here. So as I always say, gov.uk is the only genuine website which you should trust. On my channel, I've provided loads of videos related to all the content is from gov.uk, and if you have any question, feel free to contact. You can watch all these videos. These videos are there to help you. So if you wanted to send me an email at dr_khan@consultant.com.